Okay, good afternoon, everyone. This is Michael Payne, and I'll be introducing the presenters in a moment. Welcome to our webinar on avoiding common mistakes in federal construction contracting. Joining me today are several of the attorneys on our staff. I just, by way of housekeeping, want you to know that we ask everyone to be muted upon your entry into the webinar. You feel free to ask questions by typing them into the Q&A box, and we will monitor those and either handle them as they come in or at the very end. And the webinar is being recorded, and copies will be available to everyone in due course. I'm Michael Payne, and I'm the chair of our firm's federal contracting group. In another life, I was the division trial attorney for the North Atlantic Division of the Corps of Engineers. And over the years, between my government experience and private practice experience, I've seen just about every situation that can come up in government contracting. I'm joined by our Washington, D.C. partner, Casey McKinnon, who again focuses entirely on government contracting and has become very involved in a lot of the issues of the day, Buy American, economic price adjustment, bid protests, and so forth. Also, I have with us Steve Tobin in our Washington office. Steve joined our firm a little over a year ago and spent a number of years in the headquarters office of the Navy Facilities Engineering Command. And he brings a perspective of not as far removed from the government as some of the rest of us. And he will contribute some of the government perspective. We also have David Petrone, who was at one time the regional counsel for the Northeast region of the Navy Facilities Engineering Command, another attorney with a wealth of experience, and Ryan Boostra in our Philadelphia office, who is very involved in all of the matters that we handle. So although Casey, Steve, and I will be the main presenters, others may contribute as things come up that they feel would be of interest to the group. All right, you may wonder why we're presenting a seminar that deals with how to avoid making mistakes. You would think that maybe lawyers would say, well, we like it when our clients make mistakes because that brings business to us. But I can assure you that that's not the way we look at it. As a matter of fact, the government causes enough problems that we're pretty assured of having business from that alone. And if we can help you avoid some of the things that are truly avoidable, that's what this program is all about. This is the first in a three-part series. The second part will be common mistakes during contract performance. That's going to be presented on September 13th. And then part 3 is common mistakes during the REA claims and appeals process, and that'll be on October the 6th. So we'll be focusing on the 3 discrete areas of problems that we've addressed, and we invite you to join the remaining webinars as well. The reason we start out by saying this is the hard part is that I've always noticed over the years and admired the difficult task that government contractors have. Back in the days when sealed bidding was the predominant form of federal construction contracting, the awards were very much dependent on being the lowest price. And I marveled at how tricky and difficult it was to be the lowest price at a price where you could not only get the award, but make a profit. Because it's not too hard to come up with a low price and lose money. And of course, if your price isn't well thought out and very competitive, then you may not get the award. So it's not easy to be involved as a government contractor. As I said, years ago, almost all federal construction contracting was done by sealed bidding. And that meant that in order to be awarded a contract, you had to be the lowest responsive and responsible bidder. Responsiveness simply meant that you comply with all the material terms of the solicitation. Responsibility just meant are you able to demonstrate that you have the capability in terms of your performance experience, your equipment, your financial wherewithal to perform this project. Contractors would sometimes get into problems by making mistakes in the way they approached the bonding for the project. And I can't tell you how many cases we had where very technical errors were made in a bid bond. I remember one case in particular where the bid bond was to be in 20% of the penal, the 20% penal sum of the contract award amount. As I recall, it was about a $2 million contract, and so the bid bond would have to be good for 20% of that, or $400,000. The problem was the power of attorney form attached to the bid bond said that the attorney, in fact, who had signed on behalf of the bonding company only had authority to bind the bonding company up to $100,000. So when the government noticed it, they rejected it as a defective bid bond, which was not properly authorized. Seemed like a harsh result. The bonding company immediately contacted the government and said, hey, we can fix this. It's our mistake. It's clerical error. This is the only person in our office who has a limitation of authority. Shouldn't even have been signing that power of attorney. We'll substitute a new one and you'll have it very quickly. We'll fax it to you. The problem with that is in sealed bidding, you have to stand on whatever it is you submitted at the time of bid opening. You can't correct a bid or a bid bond after bid opening. So problems with bid bonds and making sure that they're technically accurate is something that's important. And for that reason, it's usually important if there's a public bid opening to attend. Now, I realize we're living in the hopefully post-COVID world, so there are not as many live bid openings as there used to be. But you know, you want to take a look at the bid package, or at least the abstract of bids, and see if you can find any errors that competitors may have made that might give you an opening to become the low bidder. The abstract of bids is something that you should always get. And of course, remember, in sealed bidding, it's the identification of the apparent low bidder that is made at bid opening. The apparent low bidder may not end up being the low bidder. The government may reject that bid as non-responsive, may find the contractor to be non-responsible. So any one of a number of things can happen, so you should be somewhat alert. Unlike just about any other form of construction contracting, whether it be at the state, or local, or private level, there is a pretty formal mistake in bid procedure at the federal government. So that if you have truly made a mistake in your bid price, there's a possibility that you can withdraw your bid without penalty and without your bid bond being assessed. Or in some limited cases, you may be able to correct your bid price to raise it to a higher price and still remain the low bidder. The key to being able to do that is to put the government on prompt notice and to realize that you're going to have to convince the government by clear and convincing evidence that a mistake was made. And either that, and once you do that and show that a mistake was made and prove it, generally the government will let you withdraw. But if you want to go that further step and say, not only was a mistake made, but here's what the mistake was, and I can prove to you what my bid should have been by papers that were in my possession and that were prepared before I submitted my bid, then you may be able to correct your bid upward. It's a somewhat complicated procedure, but we've been able to successfully get relief under those provisions. Naturally, you can understand that the next highest bidder is not very happy if the low bidder is allowed to raise its price rather than withdraw. But just be aware of the fact that that procedure exists. Now, in just about any kind of federal procurement, really understanding the solicitation is very important. And that's why using the pre-bid question and answer process is important. If you're invited to submit questions and you're usually given a deadline, get them in. I know sometimes contractors are worried that they may be giving away something that shows how they're approaching this project. And I know there's a bidding strategy that comes into play. But many times we've been successful in winning claims where we're able to show that something that the government is now denying ever happened or was actually present in the solicitation was actually something that was asked in a Q&A period, and the government's answer was misleading or turned out to be misleading. And the courts and the boards have held that most of the time those Q&A responses become part of the contract. So I would say approach it seriously. Now, in sealed bidding, there's also something else that comes up called definitive responsibility criteria. And Casey, that's something you've had some recent experience with, so why don't you address it?
Yeah, thanks, Michael. So definitive responsibility criteria are matters within an RFP or requirements that must be satisfied to enable you to get an award, rather than things that might be the difference between an outstanding or a good. These are hard and fast requirements that must be satisfied. And whenever you see one of those in an RFP, it warrants special attention, because if you fail to establish that you satisfy this criteria to the government's liking, you're simply ineligible for award. So we've had recent cases where a client certainly of satisfying that criteria, but maybe just didn't make it as clear as they would have liked in retrospect in their proposal. And it can lead to the need for protests and a lot of trouble in actually obtaining that award. So whenever you see one of those definitive responsibility criteria, it's worth giving it all the attention you can and ensure that you've satisfied all of those requirements to the government's liking. And make sure that that's clear within your proposal.
Casey, now before you touch on Buy American, let me just interject this. As an attorney, he's been doing this for a number of years. There is no area that causes me as much concern as a Buy American Act question from a client. I see it as the area that's the most fraught with the potential for malpractice. It's the kind of thing that lawyers have nightmares over. And in recent years, we've gotten more and more questions about compliance with the Buy American Act. And the reason that it's so concerning is it can affect your bid. And it certainly can affect what happens to the amount of money you get paid if you've made a mistake in bidding with regard to understanding the Buy American process and failure to comply with it. Casey is as knowledgeable about the Buy American Act as anyone I know, so why don't you impart some of your wisdom, Casey?
Well, thanks, Michael. And I think you touched on this a bit. It might seem odd to talk about the Buy American Act in a pre-bid phase, because typically our clients think of it as a performance problem. During performance, problems arise and it leads to higher costs. In reality, most Buy American Act violations can be tied back to the pre-bid phase. That's the root of the problems. And the law is written in a way that anticipates that contractors will look at the RFP requirements, put together a detailed list of all the materials and supplies that they'll intend on using, and maybe even submit alternative proposals that call for the use of less expensive foreign materials. In reality, we all know that that's not how things work. Especially in a fast-paced procurement, no one has a comprehensive list of every item they intend to buy or use on the project. It's just not how things work. And we run into a lot of problems with this in the design build process, because as a matter of practice, there really is no way to know all of the materials you'll need in a design build job. So the best thing a contractor can do is at the least identify what the Buy American requirements are, and specifically whether it would be the standard Buy American Act, the Trade Agreements Act, or whatever clause is going to apply and impose those requirements. Oftentimes, the government puts offerors in a very unfair position by including multiple FAR clauses that call for different Buy American requirements. And in those cases, it's very important that you request clarification through the Q&A process, like Michael alluded to find out what actual requirements are going to apply and try the best you can to incorporate those requirements into your pricing, because after the fact, it can be very hard to recover if there's been a misunderstanding during performance.
And, we welcome the questions that we get from our clients who are not sure about what they have to do to comply with the Buy American Act. And that's the thing to do. I think as much as any issue that comes up, it often requires legal analysis. And many times the answers are even difficult for us. And the government people, believe me, don't understand it either, and don't necessarily rely on what you may be told by someone in the government about whether something complies with the Buy American Act. They may be wrong. Okay, we also have the subject of exculpatory clauses. What do I mean by an exculpatory clause? That's a clause in the contract that allows the government to shift responsibility from itself to the contractor. It is something that the government will point to generally to say that, well, you saw this clause when you bid the job, and don't complain about it now. It's too late. One example that jumps into my mind is under differing site conditions, sometimes the government will say, well, you may not rely on the borings, they're for informational purposes only. Well, you're talking about a dredging job and I can't rely on the borings. You're talking about the excavation of a parking lot, I can't rely on the borings. How am I to put a bid together? And of course, Steve and his vast experience with the government knows how the government looks at these things. Steve, why don't you comment?
Yeah, thanks, Michael. So you're spot on with that last example in terms of the inclusion of boring results or any other type of testing samples in which the government is looking to shield itself from potential liability. So what they do is they go ahead and they provide the information and they'll caveat it by, again, indicating it's for reference only or for informational purposes only. And therefore, if you as a contractor come across a site materially different, a condition materially different from what's indicated in those documents, the government's got themselves a built-in buffer where they essentially can say, well, we never made that a part of the contract. That information was for you to use, consider, and adopt in your proposal. But we weren't making any type of material representation or providing some type of contractual indication as to the type of conditions you might encounter while working the project. And that goes back to this idea of informational purposes only, reference or for reference only. It goes back to the bullet point at the top on the pre-bid Q&A process. A lot of the times those Q&As do get amended into the solicitation, and therefore they become part of those contract terms. But again, what the government does typically to protect itself when it fears that a differing site condition might exist and they're not willing to commit to a specific representation about those conditions, they'll provide some reference material, some information, but again, they're trying to shield themselves from potential liability downrange if and when those conditions might present themselves. So definitely you want to be on the lookout for those types of documents.
I guess permits and responsibilities comes up as well, right, Steve?
Yeah, permits and responsibilities is another interesting clause, and that's a kind of a catch-all safe harbor, as I like to describe it, for the government, that if there's an issue that's not quite covered by a specific term in the contract, and somebody encounters a condition or a new regulation or a law, new code, some licensing requirement, the government shields itself again from responsibility for making any increase in cost to the contract by pointing to that clause, which essentially says, look, during performance of the contract, if there's changes in laws, if we as the government aren't responsible to adjust your contract, it's incumbent upon you to be in compliance. And this comes up and this causes some confusion because the government has this, a dual role, right? We look at the government as our contracting partner, but on the other hand, they're also the sovereign. And so when they're acting in a regulatory function and they're enacting new laws, that's the government acting in a sovereign function for the public good. And they are not responsible, or the government as the contractor is not responsible for those types of acts. And that's how they put up a wall to protect themselves from having to pay an increased cost when there is new laws or regulations that might increase the cost of your performance of whatever the project might be. So that's another thing to just keep in mind as you go through the bidding process and you read these solicitations.
Another thing to keep in mind, and this is the good news, is that the boards and the Court of Federal Claims generally don't like exculpatory language in a contract. If something is traditionally the responsibility of the government, then they're going to keep that responsibility in the government's hands. And particularly in differing site conditions, the courts and the boards recognize that if a contractor is given information about the subservice conditions, and there are representations made about those conditions, then that information is given to bidders so that they can put together an intelligent bid. And to then say to the bidder later, well, those borings were only indications of materials in the boring hole itself and weren't supposed to be extrapolated throughout the project. Boards don't like that, because that means that the information we gave you cannot be relied upon. And on the other hand, you have the right to rely on the information we gave you. So all of that will come up. Okay. You know, there are lots of traps to avoid in government contracting. Things that if you don't do them, in some of these cases, will get you disqualified from the get-go. Steve, why don't you start to address this topic?
Sure, this comes up quite frequently. So, and again, this goes back to the theme of understanding the solicitation and a careful scrub of it as you look through it. So what Michael's talking about, and what I'm going to give you a little more detail on, is the idea of an ambiguity or a glaring omission or mistake that's in the terms or conditions of the solicitation. There can be two kinds. Mostly the one we're talking about here are those obvious ones. They're glaring. These are called patent ambiguities, patent mistakes, patent errors. And what it is, for example, if specification says the item that the government wishes to procure must be 6 feet in length. And you see that on page 10 of the solicitation. And then deeper into the body of the document, say page 20, it again describes the item that the agency is attempting to procure, but describes it this time as being 20 feet in length. Okay, well, that is a glaring mistake or inconsistency in the terms of the solicitation. And at that point, there's a duty. The law imposes a duty on the contractor to raise that inconsistency or that mistake, whatever it might be, raise it to the agency and get an interpretation from the agency itself as to what it is they mean or they intend. Is it the 6 feet or is it the 20 feet? If you don't do that and you attempt to bid the project on your own interpretation without having brought that error forward to the agency, you will not be able to recover downstream when you have to comply with, let's say you bid it at the 6 feet width, and then it turns out the government really did want the 20-foot length. At that point, the government's going to say, well, that was a glaring omission in the solicitation terms. You had to have brought that forth. You cannot recover. You had a duty to inquire from us and you failed to do so. So you're not going to be able to recover the additional cost of bidding that particular mistake. So that covers, I think, the idea of a glaring omission, a glaring error, an inconsistency in the terms of the solicitation. Another trap you want to avoid when you're reading through the solicitation, and as you're getting ready to prepare that your proposal or your bid, is you want to acknowledge all the amendments that have been made to the solicitation. You have a responsibility as an offeror to materially comply with the requirements that the government's laid out in that solicitation. If you fail to do so, the government can deem your proposal as unacceptable and cast it aside, and you'll lose out. Now, there are material amendments and there are immaterial amendments or non-material amendments. A material amendment is an amendment that changes the legal obligations under the proposed contract of both parties. So, for example, if there's a proposal or a solicitation out there in which a proposal be submitted where the government wants 200 widgets, and you prepare your bid based on the 200 widgets. And then the government comes back later and says, no, we're going to amend the terms of the solicitation. We actually want 1,000 widgets. You have to formally accept/acknowledge that modification or that amendment to the solicitation. If you don't, as I mentioned earlier, the government can cast it aside and say, you're not being responsive to our requirements. And it's a material amendment because the difference in pricing of 200 widgets versus 1,000 widgets has a significant impact on the way you're going to prepare and bid that job. So make sure you confirm any amendments, there's a number of ways to do so. You can sign the amendments, include them in the bid package. In the cover letter to your submission of your proposal or your bid, you can acknowledge the amendments. And there's a little bit of there's case law out there from the GAO that amendments can be constructively acknowledged, even if you don't formally acknowledge in one of the more routine ways, if your proposal reflects one of the terms that has been introduced by the amendment, then the GAO and most contracting officers will say, okay, that's an acknowledgement in of itself, even if you haven't signed off on the amendment or put it in a cover letter.
Yeah, one example I ran in one time, an amendment to a solicitation changed the bid opening date. And instead of making it later, which is usually the case, it actually made it a few days earlier. The contractor didn't acknowledge the amendment, but he got his bid in a few days earlier on time. So the government said, well, you didn't acknowledge the amendment, so we're going to have to reject your bid. And our response was, well, that was immaterial because the bid was submitted on time according to what the amendment required. And we prevailed on that argument. So you're right, Steve, and thank you. Another thing that has happened over the years is late bids or late proposals. Now, in the pre-electronic era, that was a greater problem. Now, when you can submit bids and proposals electronically, as long as the system is working, it's not quite as difficult. I can remember a time when one of my clients had to submit a bid package in person at a military installation. And like many bidders, they're getting subcontractor quotes right down to the wire. And he's on the phone with the home office and making some pencil changes to the bid package and realizes he's got about 10 or 15 minutes to get to where the bid had to be delivered. And he was outside the gate. So it took a couple minutes to get through the gate. He pulled up to the building, whatever building number it was where the bids were to be delivered and opened. And he was there, I think it was like 2 o'clock. He was there at 1:58. The only problem is when he walked into the building, he didn't see anybody. There was a desk, but it was empty. There was one door and it said, do not enter, government personnel only. Well, now he's starting to get really nervous. It's 1:59 and seconds are ticking away. So he walks through that door and a government employee sees him and says, can I help you? He said, yeah, I'm here to deliver a bid package and I don't know what room the bid opening is and there's no one out there to help me. He says, oh, let me take you. It's right up here. And he got there after 2 o'clock. The bid was rejected as late. His argument was, hey, you had a responsibility to post a bid opening room if no one was going to be there to tell me, or at least have a receptionist to greet me, not just let me wander around. And the GAO said, no, you had the responsibility to get the bid on time. There were 12 bids received and the other 11 were on time. So you're out of luck. So you have to be very careful. And of course, it not only pertains to bids, it pertains to negotiated procurements and proposals. We also had a contractor during one of the recent hurricanes in the Gulf region. Internet was down and power was out. And he was about to electronically transmit his bid package and he couldn't do it. He had no internet service, he had no cellular service, he didn't have anything. The government office, which was in another state, was not having power problems and they were receiving proposals. So they rejected his proposal as being late. We, in that case, protested to the contracting officer, to the agency, and they decided, and I think it was the right and fair thing to do under the circumstances, since he could show by time stamping on the attempted transmission when he was going to send it, they decided to accept it, even though in most cases it would have been considered a late bid. But that's very much an exception. I wouldn't count on something like that happening, even in another hurricane situation. So just remember, it is your responsibility to get the bid or proposal in on time. And if you don't, you're probably going to be disqualified. Now, another thing that the government looks for is unbalanced bidding. Casey, why don't you talk about that a little bit?
Yeah, thanks, Michael. So this issue ends up being the subject of a significant number of bid protests. And in a short way to phrase it is it's in a sealed bid context when you have different line items or CLINs that you're bidding on, you take money out of one of those items and put it into another for the purpose of making your bid seem more appealing than it actually is. So you might have a evaluated price that's quite low when in reality, the government will end up paying you more down the road because of the way you've structured your pricing. And the most common way we see this is contractors who put an enormous amount of money in their MOB or demob costs. So they get that all on the front end. And then maybe the cost of performance ends up being lower than expected, and they end up with a windfall profit. And it can be very tempting to front load or otherwise unbalance your bid, but be aware that the government is on the lookout for this and other offers are on the lookout for this. So if you end up unbalancing your bid, you may end up dealing with a rejection of your bid by the government, or alternatively protests of an award to you on the basis that your bid was unbalanced.
Thanks, Casey. Now, another thing that comes up a lot lately is the use of the economic price adjustment clause. And of course, we're living in a time of unprecedented price escalation, global supply chain shortages that are affecting the prices on all kinds of products, not the least of which being fuel and many, many different kinds of commodities. And contractors who bid or submitted a proposal on a project that was before the price escalation occurred are now getting killed. And in some cases, losing potentially millions of dollars because they're unable to get any relief or get any kind of a price increase. One of the mysteries in all of this is that the government appears to be generally unsympathetic and are standing very much on the proposition that if there's a clause in the contract that provides for price escalation, then you can claim it. If there isn't, what do you want from us? We can't change the contract. And what I have found somewhat frustrating is that not all agencies see it the same way. And not all contracting officers see it the same way. I've seen situations where a particular contracting officer has said, okay, I feel your pain. We're going to issue a change order and increase the contract price, whether or not the contracting officer was required to do it. So we tell our clients there's no harm in asking, because depending on how egregious the situation is, your request may land on a sympathetic ear. But the difficult part is that if you try to take it to the claim stage and enforce economic price adjustment, you're generally going to be frustrated, and the language that's coming out and the guidance that's coming out from the Department of Defense, for example, has not been at all helpful. Casey and Steve, I know you've been running into this situation a lot. Why don't you comment?
Yeah, it's unfortunately something we receive multiple calls on per week, and it's led to a lot of frustration for clients. In some cases, we've been able to come up with some creative arguments to help people recover. One example would be if your performance would have been over by the time this escalation phase started and the government pushed you in by delaying the project, then you might be able to recover. But in order to avoid the need for those creative arguments, because we're talking about things on the pre-bid stage right now, look in any solicitation or RFP that you're reviewing for a FAR clause that speaks to economic price adjustment. And it might be a case where if you notice it's not in the contract, you can request to have that included, because as Michael alluded to, the best protection you can have here is to have it actually part of your contract, and therefore there will be a specific mechanism when the escalation occurs to help you recover. Effectively, a little bit of preventative medicine is the best way to deal with the issue here.
Yeah, Casey, let me jump in and kind of bootstrap on that comment there. So, and Michael alluded to this as well. So DOD in the end of May came out with guidance to its contracting officers, essentially acknowledging that we were going through as an industry, at least at the defense industry, was going through unprecedented periods of inflation. And it was not lost on the DOD that a number of contractors were coming into contracting officers seeking REAs for price increases. Well, DOD really kind of just put their marker down and said, absolutely not. Unless there is a clause in the contract that allows for some type of relief, that contracting officers were not to entertain and certainly not to grant REAs based on actual cost experiences due to inflation. That said, prospectively, they have counseled their contracting officers for contracts that are being negotiated, for contracts that are being developed, to discuss with the defense industrial base the possibility of an appropriate price escalation clause in the contract. So there should be some more latitude and certainly some more willingness on the part of the contracting officers, at least at the DoD level, to entertain the inclusion of these economic price adjustment clauses. Now, one thing we saw, and when I was still with the Navy, with these DoD guidances, was using that as a leverage point, going to your contracting officer. And it's tough because if you don't have that escalation clause, you're in a bit of a pinch. It's kind of hat in hand, but going to your contracting officer, presumably you have a good relationship, and pointing out, look, DoD has softened its stance prospectively. Is there a way that we can work out some type of relief, even if it's not 100% of the cost experience? So sometimes, you should operationalize some of the guidance that's out there, again, just as a little bit of a pressure point with your counterparts at the agencies. So definitely think about that.
Okay, thanks, Steve. Okay, moving into FAR Part 15 procurement, contracting by negotiation, what many of you refer to as an RFP or a best value procurement. The most important thing to keep in mind and to think about here is, what does the government want? I find that many times offerors in submitting a proposal on a government project, including a construction project, haven't spent enough time thinking about, why is the government procuring this? What is their real need? And am I, in what I submit in proposals, showing that I understand what they want, that I get it? Because if that comes through loud and clear in your proposal and negotiated procurement, you're well on your way to getting a high performance or a high rating in terms of your proposal. So understanding the solicitation is where it all starts. Steve, you've seen a lot of proposals that come in from contractors that pass across the desk of government contracting officers and government attorneys. What are the most important things that you see that need to be addressed?
Right. So let's start with the general proposition, right? So what is it that the agency is doing in the evaluation process as these things hit their desk, right? They're trying to assess the proposal and make a determination with respect to your ability to successfully perform the contract. So, that's where we start. What they're looking for and how it is that you're going to put your best foot forward is following the instructions. It seems simple enough, but look at the instructions for submitting the proposal, right? What is the content that's being requested by offerors? Are you using the proper formatting? What are the number of page, is there a page limit? If proposals are capped at 50 pages and your proposal's at 70, all right, you don't want to do that. You're going to have to make some edits. You're going to have to chop that down. Fonts, the number of copies, the way the proposal is organized. Those types of things mean a lot. If your proposal comes in and it's not in compliance with the instructions that were provided for its submission, the government's going to deem it unacceptable. Okay. And tied to that, particularly with respect to the content in the instructions for how the proposal should be organized in the subjects, be specific. Don't leave the evaluators looking for information throughout the document. You don't want to put yourself in a position where the evaluation team has to jump from one page to another, or potentially one volume of your proposal to a different volume. So be specific, make it easy. You want to instill confidence that the government knows what they are getting when you submit their proposal in terms of what the proposed performance is going to be and how it's going to be carried out, right? So you want to talk about your best effort forward, best forward effort. Understand what the evaluation factors and how those are going to be evaluated. You know, management, staffing, subcontractors, your past performance. All of those are important. All of those are usually included in solicitations because the government wants to know how in those particular areas you're going to be able to perform. They've made a decision that those particular factors are the ones of most importance to them that will give them confidence that you're going to be able to perform the project successfully. So when it comes to those factors and sub-factors, pay attention to how they're weighted. For example, is management 10%? Is staffing 15%? Don't put your eggs all in one basket. Understand, again, how much value the agency has communicated to you as a proposed offeror, how much value they believe should be apportioned to each different topic or subject area for evaluation. Most importantly, address each specific requirement. You want to, again, demonstrate and instill confidence in the agency that you understand their needs and you're going to be able to successfully perform those needs. So you want to make sure that you've gone to every requirement that's been listed in that solicitation, and you've addressed it as specifically as possible with as much detail as possible, which all ties back to that thread of, one, understanding the government's needs, and two, making it crystal clear you know how to meet them and the evaluators see it on the face of the document and not having to dig around for it. So I think those are some of the most important things to keep in mind as you put your proposal together.
Yeah, good point, Steve. And some of the best proposals I've seen are ones where the contractor actually anticipates that something could go wrong, not his fault, but that something could go wrong, and suggests what he'll do about it or how he has a backup plan. The government loves that sort of thing. Sometimes they specifically ask for it, but even if they don't ask for it, I've seen source selection memoranda which comment that, well, this contractor went so far as to tell us what he would do if something was late or this happened or that happened, and he got extra points for it. The other thing that comes up is experience qualifications and qualifications of personnel. You know, many times you'll submit resumes. You'll be requested to submit the name of the proposed quality control manager, the project superintendent, other key personnel. And most contractors will do it by submitting a resume. Well, everybody hates to update their resume unless they're looking for a job. So you give them a resume that's 2 or 3 years old, well, you may be shooting yourself in the foot because it doesn't provide some recent experience that would have been helpful. And also you have to be careful that make this resume pertinent to the type of work that's involved in this project. If this project is to pave an airfield, showing your familiarity with dredging may not be all that helpful. You might want to show that you have people with experience in airfield paving or in construction of a hangar or family housing rehabilitation. So make your experience as relevant as you can. I know I was in a client's office one time and he was lamenting the fact to me that he had submitted over the last few months several proposals to a particular agency, and he lost every one of them. A couple of them, turns out he had the best pricing. He said, why do I keep losing these? And I said, well, I can't tell you off the top of my head. If you want to show me examples of your proposals, I'll see if I can pick up anything. He said, great idea, Mike. He said, here's one right here. Why don't you take it back to your office and tell me, critique it for me. Tell me why I lost. Well, it turns out a little later, we took a break. So I started leafing through the proposal while we sat there. Took me about a minute and a half. When he came back in, I said, I don't need to take this back to my office. I can tell why you lost. He said, why? I said, it said here that you were to specifically identify and provide a resume of your quality control manager. And you put to be determined. He said, well, I haven't hired him yet. I didn't get the job. I said, that's not what the government wants to hear. They want to know that if you get the job, that this is the person who's going to be in that important position. And it's a person who's well qualified. And if you haven't hired them yet, then get someone who's a prospective employee. Maybe have some sort of a letter of commitment with that employee that if you get the job, he's going to be hired or she's going to be hired. But don't say to be determined. The government doesn't know what that means. You lost. So those kinds of things are very important. Now, many procurements have specific requirements with regard to joint ventures and teaming requirements. Casey, why don't you talk about that a little bit?
Yeah, sure. So most of our clients are often, when we're talking to our clients about whether they're going to use a joint venture, committed subcontractors, or simply a more informal teaming arrangement. In the real world, those are discussed somewhat interchangeably. Sometimes the terms are used loosely and kind of conflated to be one and the same. So not much difference maybe in someone's head between a joint venture versus a committed teaming arrangement. But if you look to the terms of an RFP, often the rules for the procurement treat those two situations very differently. So we've run into cases where our clients were very frustrated, didn't receive an award, and it's because maybe another competitor submitted as a joint venture and their past performance was given more credit than, say, a prime contractor subcontract arrangement, and the subcontractor's experience wasn't given the same consideration. So it's important to look into that RFP and figure out which sorts of arrangements are permissible, and is there a difference between the way they're treated. In particular, past performance and experience are the two things to look for, because there are certain cases in which one structure versus another will give you an enormous leg up in presenting your past performance and experience, where maybe another setup where you have a prime subcontractor relationship won't get you the same credit just based on the terms of that solicitation. So you want to look at that and then make decisions about how you might want to structure your team based on the sort of consideration that the RFP permits.
And along those lines, know something about the type of procurement that you're involved in. There are IDIQ contracts in this day and age, multiple award contracts. You don't see too many single award task order contracts, SATOCs anymore, but you do see MATOCs and MACs, which are a multiple award contracts. Pay attention to what the seed project requirements are, because if it's very likely that an evaluation of price and other factors is going to be heavily dependent on how you approach the seed project. And be particularly alert to how many prospective awards are going to be made. Are they going to make, 2 awards, 4 awards? Do they say between 4 and 10? It's all over the place. And one of the things that we've noticed is sometimes the government will make awards at the low end of the scale. When they had a range of 4 to 10 and they award 4, and you look at why you were not selected, and it's pretty clear that you were number 5 if you rated them, and it's a pretty close number 5. Well, that's a time to talk about a protest. And it's the kind of protest you can win, because one of the easiest things the agency can do if they realize that they were a little bit too harsh is they can say, okay, we'll take corrective action and we'll admit you as part of the group. So you need to be alert to things like that. Okay, you submit a proposal, and why are you not selected? And back in the early days of the conversion from sealed bidding to negotiated procurements, we used to get a lot of calls from contractors. Hey, I was a low bidder and I didn't get this job, and how can they select somebody else? And we had to explain, well, this is a best value procurement. And the price is not the only determining factor. And the government determined that your past performance wasn't very good, or your technical approach wasn't very good. And that's why you didn't get it. Well, as the years have gone by, obviously contractors have become more educated and attuned to how to put proposals together and what the system is all about. But again, in the proposal, show that you understand exactly what the customer wants. And that goes in line with some of the things that Steve was talking about. Misinterpreting the requirements or making it obvious that you're misinterpreting the requirements is a big problem, because if you write something in the narrative part of your proposal that shows that you don't understand, then that's going to come back to haunt you. I spoke earlier about the failure to anticipate problems. While it may not be specifically required that you anticipate them in your proposal, it's always a good idea to do that. You don't want to take exception to the solicitation requirements. You might in your proposal want to propose an alternate way and say, look, we're going to give you exactly what you're asking for here, but by way of suggestion, we are also prepared to do the following. And if it strikes the government as something that's well thought out and a good idea, that may get you some extra points in your technical approach. There are a lot of contractors that are really, really smart business people. They know how to bid a job. They know how to perform a job. They just can't write a simple declarative sentence all that well. A poorly written proposal is something that you should avoid because it says something about your company. Even though the substance of the proposal may be very good, if the government sees grammatical mistakes, spelling errors, run-on sentences, things that just don't make sense, that is going to hurt. So if you're not someone who's particularly well-versed in that type of technical writing, get someone to help you. Because the way the proposal is written and the kind of support that you provide for the statements that you make is more important. Don't just puff and say, we're the greatest contractor in the state of Oklahoma. Okay, what basis do you have to make that statement? If you follow it up with, we received 6 awards from the governor as the contractor of the year, okay, then maybe your statement makes some sense. But just don't make bold, blanket, unsupported statements. And as Steve pointed out, don't put information where it can't be found. And, you know, unrealistic schedules, pricing that just doesn't pass the pricing realism test that the government sometimes will subject a solicitation to, or suggesting a technological advance that may be beyond the state of the art. Those are just some of the reasons that the government will say, okay, this proposal is going to get a lower score. And generally speaking, don't waste your time by protesting those kinds of conclusions by the government. You may think that you were given a score of C when it should have been a B. Chances are the GAO or the Court of Federal Claims are going to say, well, that's up to the discretion of the contracting officer, and we're not going to substitute our judgment for the contracting officers. So you have to be alert to that sort of thing. Okay. Debriefings are very important. If you want to have the right to file a protest with the GAO, for example, it's a requirement that you request a debriefing. And Casey and Steve get involved in these quite a bit. So what are the things to know and to remember with regard to debriefings? Casey?
Yeah, from my perspective, and particularly if you're trying to think about a bid protest, you should always request, in fact, you must request a debriefing when one is available, and treat it as a collaborative, cooperative, diplomatic process. If you go in and start demanding answers and you're aggressive, the government personnel have really no reason to share information with you, and you can only gain by learning of that information. It can help you preparing your next proposal, and you might learn about protestable information on the current procurement. So be diplomatic, do not be hostile. And in general, sometimes our clients ask if we could join them, if counsel could join the debriefing. And we advise against that because it tends to lead to less information being shared. Government personnel are wary of sharing information with attorneys. So instead, we simply prepare questions in advance and then have our clients take detailed notes and share them afterwards. But in general, because we're short on time here, my advice is simply to be open, be friendly, and try to gain as much information as you can.
And you can get a little bit more time in filing a protest beyond the 5 or 10 day deadline that might apply by taking advantage of the DoD's advanced debriefing procedure, which allows you to submit questions after the debriefing, which further postpones the time that you need to file a protest. And we generally do that if for no other reason to pick up a few days. So then, the question becomes when to file a protest. One of the most frustrating types of conversations I have to have with clients when they describe what's happened to them and they want to know what my advice is on whether to file a protest, I often have to say, well, what you're telling me doesn't sound very good. I think you may have a basis for the protest, but the problem is all the records and the supporting documents are in the hands of the government. So the only way we're really going to know if you have a good case and if there's really fire where there's smoke is let's file the protest. And then we can get the government's documents, and then we'll be in a better position to assess whether you have a good case or not. If you don't, you can withdraw the protest before spending more in legal fees to pursue it. If, on the other hand, it looks like whatever you suspected really did happen, and it's just as bad as it seems, then we go charging ahead with the protest, and we've now, we've now got this additional information. But Casey and Steve run into these kinds of questions all the time about whether to file a protest. Very quickly, any comments on that subject, Casey and Steve?
Yes, my one, since we're short on time, is that timing is very key in the protest process. The deadlines are very short, and there is no opportunity to sit on information and see if it works out for you later. So if you have a problem with the terms of the solicitation, you must protest that before proposals are due. If you find out about an award to a competitor that you're unhappy with, act quickly, because if you sit on that information, you'll be out of time and be unable to file your protest.
And you have to choose your forum. You have a choice of going to the agency, which is usually not the place to go because they've already ruled against you, the GAO or the Court of Federal Claims. Most of the time we go to the GAO. And what it's nice to win, but it's tough to win. One of the best outcomes is if you get what's called corrective action, where the GAO requires the agency to go back and take another look, or the agency decides, once they think about your protest, that you've made a good point. So, get good advice about whether you have a decent argument, and then in an appropriate case, go ahead and protest. And then last but not least, managing expectations is something that we try to help our clients with. You have to know when to let it go. Sometimes with a claim, we tell our clients, don't fall in love with your claim, get real. Well, the same thing is true with a protest. One of the things that the GAO and the courts will look at is whether or not there's a rational basis for your argument. The government's position doesn't necessarily have to be the best one. The decision that they've made doesn't necessarily have to be the same one that a judge or the GAO would have made. It just has to have a rational basis for it. I had a judge tell me one time that he agreed with my argument in the Court of Federal Claims, and that if he was the contracting officer, he would have found for my client and awarded the contract to him. He said, the problem, Mr. Payne, is that I can't say that what the contracting officer did here was irrational. I disagree with it, but there was a rational basis for it nevertheless, so I have to sustain their position. Well, that decision was like sticking a knife in my heart. I really disagreed quite a bit with what the judge said there, because if he felt that they should have gone a different way, then maybe that did mean that there wasn't a rational basis. But you have judges and you have GAO attorneys who will look at it that way. And as I said before, they won't substitute their judgment for that of a contracting officer. It's very difficult to get an evaluation overturned. And if you can get corrective action and another look, that's pretty much a win. Okay. We've covered a lot of material. I hope we've given you some things to think about. You certainly can feel free to email any of us if you think of follow-up questions. If anyone wants to type in a question for us to address now, feel free to do so. Other than that, we've enjoyed making this presentation. We look forward to the follow-on ones where we'll go into some detail on what happens during performance and post-performance, and we hope you'll join us for those as well. Okay, I don't see any questions pending, so thank you very much.